Well, can I welcome everyone to the next in the Global Public Law Seminar Series of the Centre for Comparative Constitutional Studies. I'm Cheryl Saunders from the Centre, and I'll be chairing the seminar this evening. And let me begin by acknowledging that I'm speaking from the lands of the Boonwurrung people of the Kulin Nation, and I pay my respects to their elders, past and present. The theme of tonight's seminar is researching public law. It's a subject of a soon-to-be published edited book on researching public law in common law legal systems under the imprint of Edward Elgar. This is in a sense an early launch of the book, but the seminar is primarily designed to explore some of the book's key ideas. And to that end, we're fortunate to have with us tonight Joe Tomlinson, who with Paul Daly is one of the two editors of the book, and three of the contributors responsible for three of the most diverse and interesting chapters in the book, Jason Varuhas, Theunis Roux, and Janna Promislow, who have written respectively on doctrinal method, comparative method, and Indigenous approaches. The format for tonight's seminar is that in a moment I will introduce all four participants. Each of them will speak in the order in which they're introduced for an allotted time. And that last presentation by Janna Promislow, who's in Canada, will take the form of a pre-recording. We hope there'll be time for questions at the end. And if you're interested in asking a question, which you're very welcome to do and encouraged to do, please use the Q&A function. We hope you'll enjoy what promises to be an extremely interesting seminar. So let me begin with the introductions. The first speaker will be Joe Tomlinson. Joe is, as I said a moment ago, one of the editors of the book, as well as a substantive contributor, of course. He's Professor of Public Law at the University of York. He's also a member of the academic panel at Blackstone Chambers, an associate fellow of the Public Law Project, and co-editor of the academic panel of the Administrative Justice Council. His research focuses primarily on public administration, where he explores how law operates in contemporary administrative systems, often with an emphasis on systemic issues. He's also interested in how these systems are perceived and experienced in everyday life. And so you can see where the impetus for the book came as far as Joe is concerned. Our second speaker is my colleague, Jason Varuhas, who is Professor of Law at Melbourne Law School, where he's Director of the Centre for Comparative Constitutional Studies that is presenting the seminar this evening. He's also Director of the Public Law Conference, the leading series of international conferences on public law in common law systems. His research interests are diverse. They lie across the fields of public law, private law, remedies, and legal method. The third speaker is Theunis Roux, a Professor of Law and Head of the School of Global and Public Law at the University of New South Wales. He was formerly the founding director of the South African Institute for Advanced Constitutional Public Human Rights and International Law, which is where I first met him many years ago. He researches in the area of comparative constitutional law, with particular interest in the law and politics of constitutionalism in the Global South, an important emerging area for the methodology of public law. And finally, we'll hear from Janna Promislow, who is Associate Professor at the University of Victoria in Canada, Faculty of Law. She's currently the law theme co-lead in the Modern Treaty Implementation Research Project. Janna's teaching and research interests encompass constitutional and administrative law, Aboriginal law, treaties, colonial legal history, Indigenous settler relations, Indigenous law, and legal pluralism. So let's get underway. And Joe, we start with you. Thank you.
Thank you very much, Cheryl, for that kind introduction. And thank you to the Centre and Jason for organising this seminar. I just want to start by briefly introducing the book and why we decided to try to bring the book together. And some of the reasons why we wanted to start, or try to start through the book, a conversation about methods in public law. I should say that from the outset, we were slightly nervous that starting a conversation about methods, or trying to advance a broader conversation about methods, we knew could be counterproductive, because there's always a risk with methodological conversations that you end up focusing too little on the substance and too much on the method. So we approached this project tentatively, but our idea was essentially that we wanted to try to fill a gap in the literature and have a broadly comprehensive, or as comprehensive as possible within the limits of the book, discussion on methods in public law. Our starting point was the observation, and I'd be very interested to hear different people's perspectives on this, that we often don't focus on methods in public law scholarship. Now, whilst there has been some very interesting discussion on methods over the years in public law, there are also many areas of the field where we basically don't talk about methods at all. That's not to say that we don't have methods and we don't use different methods, but that usually our different methodologies are often implied. I think I've had, just to draw up some personal experiences, I've had some really interesting, to put it, kind of experiences around methods in my career so far. I'll give you one example. I was once told, I won't name the journal, by an editor, this is perhaps best to delete the method section and not have it at all, for fear that it would attract a more critical review. So methods have this very, in our view, quite unusual status within the field. Some people wanted to talk about it more. Some people really didn't want to talk about it very much at all. So we thought we wanted to sort of try and have a broader conversation about it and see what came of it. So we pursued that idea through the book, which will hopefully be coming out early next year. We couldn't hope to be comprehensive in the book. There are so many different methods and approaches that you can take to the field of public law. Obviously, we ducked the difficult question of what is public law and tried to have a broad conversation about the broad field. But we were very lucky to engage a diverse range of authors and try to set out a diverse range of approaches to public law across the chapters. So the book features chapters on more what we might call traditional methods in public law, such as doctrinal methods, methods such as socio-legal studies. Also has some chapters on what we might call more technical methods, like empirical research methods and comparative research methods, and also some chapters on what we might call some more critical research methodologies, such as Marxist approach to public law. Those are broad labels, of course, but we try to cover a spectrum of different approaches to the subject. And we asked each of the contributors to essentially explain a little bit about what is the value of the method from their point of view. So why do they think that's a valuable approach to public law? But we also wanted them to very much answer the question of practicalities. So what kinds of challenges are involved in doing that kind of public law research compared to potentially other kinds of public law research? So hopefully what we've pulled together, and you'll be able to judge this for yourselves, hopefully early next year, is a broad range of chapters that set out the value of different methodological approaches and also highlight some of the practical challenges. And we start off the book in our introduction, Paul Daly and myself, by outlining some themes that we noticed during the creation of the book. And so we were lucky enough to have lots of discussions with the authors. We hosted various author workshops, and certain themes came up often. So I just want to summarize some of those themes. First is the pressures to focus more on methods that contemporary academics face. And I'm just going to note 4 of those that I think are affecting contemporary public law scholarship. So the first is to essentially improve scholarship. So the idea that we should be transparent in our reasoning, transparent in our approach, has a lot of virtue in my view. But more broadly, public law scholars are engaging more and more outside of public law. Now, that could be with practitioners or policy officials, but it's also with other disciplines that expect different methodological standards. So that has caused, in many areas, more of an introspection about how we do our own work and how we are able to convey what we're doing to outside of our field. But there's a broad pressure, it seemed to us, for public law scholars to be more transparent about how they are answering questions that they're addressing. A second pressure comes from teaching and research supervision. With a field where method has often been implied, left unspoken, it can often make the subject more difficult for those who are new to the subject to access. So often when I take on a new PGR student, it's often the case that you have to explain to them different implied schools of public law, and you have these people who do this kind of thing over here and these people who do this kind of thing over here. And that seems quite an unsatisfactory way of trying to teach people how to engage, particularly in research in the area of public law. So there seems to be pressures coming from teaching and supervision, which force us to be more transparent and open about how we are answering the questions we're looking at. Another pressure is the increasing need and, in some places, desire to get research grant funding. Often when you're applying for money, quite understandably, the people you're applying to get money from will want to know what you're going to do and how you're going to do it. So there's almost always on a research funding application, in my experience, a method section. It's obviously not very desirable not to have anything to say in that section. So there's a sense in which those kinds of external pressures are also forcing scholars to think more and more about what approach they're taking, how can they defend it, how can they be transparent about it. And finally, there were broader institutional pressures that were clearly at play. So it was quite often the case that when we had our author workshops, we would start with the authors presenting their chapters on methods in public law. And by the end of the workshop, we were talking about institutional culture and demands and pressures. And one of these, just to give an example, is in the UK, we have the Research Excellence Framework. All our works and selected outputs are rated every 6 or 7 years, 1 to 4 star on various criteria. And there seems to be an impression that high quality work might be work that's methodologically rigorous, methodologically clear and transparent. And we've just had the results of the last ref, and in the feedback that we've seen, there was a suggestion that empirical work with a clear methodology was much more likely to reach higher rankings than other work. I'm not saying that's necessarily a positive development, but those kinds of institutional pressures are clearly having an effect. So overall, there are, in my view, some very good reasons to think more about methodology, to reflect on our own practices, to try to improve our work, make it more sophisticated and defensible. But there are also definitely some other institutional pressures at play, and we should be realistic about those. I'm just going to close on something that we also mentioned in the introductory chapter. Perhaps the biggest lesson that we took from this is, for having the discussion with such a range of excellent authors, was the need for humility. There's a sense in which that a lot of our methodological discussion in public law over the years has been not really talking about method, talking past each other, and often trying to say that we're right and you're wrong, etc. What we saw in the discussions and what we see in public law research generally is that a good positive methods discussion can help us understand different types of research better and the value of it and how they link together better, rather than just saying, that's not my kind of research, I don't do that, I don't agree with that kind of methodology. So a positive methods discussion, in our view, is one where there is humility about what we can learn from research that is undertaken through different methods and not necessarily the methods that we would adopt. So we've seen in other fields, sadly, fields devolve into methodological camps and quite clear lines drawn between them. And we've seen in some areas a focus on method at the expense of substance. That would be a mistake in any field, in our view. So there's a real need for people involved in this debate to engage in it in a way which is not about saying, essentially, my method is the superior method, but to recognize there isn't necessarily a superior method, and there are things we can learn from different methodologies when deployed in this field. I think I'll stop there, Cheryl.
Yeah, thank you very much, Joe. That's been a wonderful introduction to the impetus for this interesting project. And we look forward to seeing the book when it comes out next year. You must let us know, and we can let the participants in this seminar know as well. And very thought-provoking. So thank you very much. Jason, you're next.
Thank you, Cheryl. Good evening, everyone. So my chapter of the book is entitled Mapping Doctrinal Methods. And as the title suggests, it seeks to deepen our understanding of doctrinal approaches. Now, there's a lot in the chapter, and I can't cover everything in this talk. So my aim is to address some of the chapter's key claims and themes. So the basic question with which doctrinal scholarship is concerned is, what is the law? And as such, a doctrinal method is the primary method for the study of law, upon which all other methods necessarily depend. So before one can apply empirical, sociological, or historical lenses to deepen understanding of the law, one must first understand what the law is. So all those interested in legal research must be capable of applying doctrinal method. And that's not to say doctrinal method is superior to other methods, but it's a necessary prerequisite for fully understanding the law. So doctrinal method is often presented as a single methodology. However, a core claim of my chapter is that there are several types of doctrinal method which are meaningfully distinct, but linked by a common concern to state what the law is and to understand the law on its own terms. The chapter identifies and elaborates upon 4 methods, and I'll come to those in a moment. But before that, I think it's important to address 2 preliminary points. First, the idea of the internal perspective, and second, the premises underlying doctrinal methods. So when one engages in doctrinal research, one does so from an internal point of view. One is not seeking to understand legal practices from the external perspective of another discipline, such as sociology, economics, or politics. Rather, one is seeking to understand the law on its own terms in the way that participants in the practice of law, such as judges and practitioners, understand it. So it follows that doctrinal method is a constrained or circumscribed way of thinking. First, the doctrinal scholar is constrained in that they're seeking to understand practices which emerge from a specific set of materials, namely legal materials such as judgments and statutes. There is, so to speak, a closed or sealed system from within which answers to legal questions must be sourced. And second, the doctrinal scholar is seeking to understand these practices as a participating member of an interpretive community, which includes judges and practitioners using the received methods of that community. So to argue that X or Y is the law is, in the words of A.W.B. Simpson, to participate in the system, not simply to study it scientifically. Just as a guild has certain methods relating to their craft, which are learned and internalized, so too do lawyers. So as Posthumus says, legal reasoning is a competence learned and exercised through participating in a common practice. And the principal audience for doctrinal work is this legal professional caste, and the touchstone for whether any account of the law is successful or not is whether it's accepted as plausible by this community of insiders. So a doctrinal scholar is doubly constrained. They must source legal answers from within the closed system, and they must do so using received methods of the legal class. Now, my second preliminary point is that doctrinal reasoning is underpinned by a number of core premises. Now, in the paper, I explained that these premises include the continuity and reasonable stability of law over time, and that law and legal decision-making is characterized by rationality. The doctrinal scholar thus proceeds on the basis that law and legal decisions are capable of rationalization, and rationality here denotes ideas of reasoned justification, non-arbitrariness, and internal consistency. Now, it seems no coincidence that these premises that underpin and inform legal reason reflect desirable aspects of law, what might be called rule of law values. So Postuma considers these features to be necessarily characteristic of law, because without these features, law would fail in its fundamental task of guiding action. So if law were constantly changed, chaotic, or the product of gut reaction, rather than stable, rationally ordered, and the product of reason, no one could plan their affairs. Now, some would respond that those premises are unreal, that law, being the product of myriad decisions and statutes over centuries, is far from rationally ordered, and if anything, chaotic. But this is to misunderstand the doctrinal scholar's role. It's the very task of the scholar to seek order from materials that may appear chaotic. That is, to identify an intelligible order that would not otherwise be apparent absent application of doctrinal methods. And indeed, it's in significant part because of doctrinal scholars, and particularly the pioneering work of the treatise writers from the 18th century onwards, that the common law of today is in much better shape than the ancient common law. And in this connection, it's important to observe the dual character of doctrinal work. Authoritative doctrinal work at once states legal practices, received legal practices, and simultaneously constitutes those practices. Through that process, the common law has over time become characterized by a greater degree of rational ordering. So let me now move on to doctrinal method itself. So in the paper, I argue there are at least four doctrinal methods. And in summary, these are as follows. So first, there's description, which might, for example, involve summarizing a case. Secondly, there's derivation, which involves distilling legal propositions from legal materials. Now, legal propositions might be described in various ways, such as rules, principles, doctrines, or tests. What matters is that they provide the normative basis for judicial decisions, as opposed to their factual basis. They explain in legal terms why cases have been decided one way or the other. Now, third is the method of systematization, which involves the organization of interconnected legal propositions into categories which form part of a wider system. So that is, each legal proposition is conceptualized as one part of a larger whole. And it's through this method that one gets the idea of fields of law, such as judicial review or human rights law, and conceptual categories such as legality, rationality, and procedural fairness. And fourth is the method of interpretivism, which involves interrogating the normative justifications which explain legal propositions or categories, and refining one's account of these legal phenomena by reference to the normative justifications. Interpretivism might also be described as doctrinally grounded theory. So it's important to observe that accomplished pieces of legal reasoning will deploy all of these methods. And it's also the case that each successive method builds upon the others. So derivation necessarily involves description. Systematization necessarily involves description and derivation. And interpretivism incorporates the other three methods. So in this way, the relationship of the methods to one another resembles a Russian doll, the outer doll encompassing all of the dolls within. Now, it's also the case that each successive method is more sophisticated and liable to offer deeper insights into the law. So interpretivism is the highest form of doctrinal method involving interrogation of the law's normative foundations, but it's also necessarily dependent on the other three methods. Now, because of time constraints, I'm going to focus in this talk on systematization and interpretivism and the relation between them. So systematization is associated with the treatise tradition. According to this method, legal propositions are the basic units of analysis. Systematization involves organizing these propositions into a scheme which evinces an internal deductive logic. So first, propositions are grouped with other propositions on the basis they share similarities and distinguished from others. This grouping produces legal categories. Just as individual propositions are mutually exclusive, so too are the categories formed from aggregations of propositions. So as such, logical contradictions are ruled out. Second, the schemes produced by systematization are hierarchical. Propositions at a lower level in the hierarchy are linked and encompassed by a more general category at a higher level. So for example, a proposition such as the no bias rule in judicial review is part of the broader category of procedural fairness, which in turn is part of a broader category of grounds of review, which is part of the meta category of judicial review. So borrowing a metaphor from Lord Gough, if individual legal propositions are valuable specks sifted from a raw mass of materials, the schemes produced by doctrinal scholars are mosaics built up from the tiny specks to produce a discernible picture of the law. Now, within such a scheme, individual propositions are at once distinct, occupying their own space in the normative environment, but simultaneously they're interconnected with other propositions and that they're dependent on other propositions, or their meaning or application is affected by other propositions. So when a scholar produces such a systematized scheme, what they're doing is they're advancing a hypothesis as to the correct statement of the law, meaning they're seeking to capture the received proper or normal body of legal practices. And whether they're successful depends on the reaction of the interpretive class. If scholars, practitioners, and judges accept the account as plausible, it shall be authoritative and will be relied upon. So we return to the idea that the expositor of an authoritative work at once provides an account of received practice and simultaneously plays a role in constituting that practice. Now, this sort of systematizing work, epitomized by the legal treatise tradition, has several benefits. Now, in particular, it provides practical guidance, a framework for thought and legal decision-making, and the conceptual categories produced by such works provide a sort of lingua franca, which enables effective legal communication. So, for example, in judicial review, the categories of standing, grounds, and remedies serve to organize thought and provide a common basis for discourse and action. But the principal shortcoming of systematization is that it does not involve a serious attempt to elaborate the theoretical basis of propositions or conceptual categories. Rather, conceptual schemes are often presented as self-explanatory, self-evident, and value-free. Now, this is problematic for several reasons, including that we are left in doubt as to whether given propositions are justifiable or conceptual categories are normatively significant. Well, the value of legal practices shall be obscure if their normative significance goes unelaborated. Moreover, where there's a question as to how the law ought to develop or how to resolve a conflict between propositions, we'll lack the deeper normative understanding which enables us to rigorously resolve such conundrums. So as Posthumus says, regimentation of terms or notions to a general map of concepts is no guarantee of deepened understanding. So systematization has a number of benefits, and it's a fundamental aspect of legal reasoning, but ultimately it's intellectually unsatisfying. So the limits of systematization and the treatise tradition lead us to interpretivism, or doctrinally grounded theory, which is the highest form of doctrinal method. Such approaches involve the explicit interrogation of the normative justifications for particular propositions or fields, and refinement of one's account of those propositions or fields by reference to those normative underpinnings. So whereas with systematization, there might be a theoretical thread latent in the scheme presented, with interpretivism, the theoretical dimension is the product of considered reflection, and there's direct engagement with the law's normative foundations in constructing and rationalizing the scheme. So a defining feature of interpretivism is articulation of what might be described as second-order, deep, or archetypal propositions. Now, these archetypal propositions stand behind, explain, and justify first-order propositions. So normative goals encapsulated in second-order principles are mediated through or concretized within more detailed first-order norms. That is, the normative goals of a field are immanent in first-order norms. So, for example, standing behind the judicial review ground of procedural fairness might be an archetypal principle of dignity. The archetypal principle simultaneously explains and justifies the law of procedural fairness and the detailed norms within that category, such as the hearing and bias rules. The second-order norm of dignity provides a rational basis for grouping detailed norms together under the umbrella of procedural fairness. These norms share a common purpose, which is distinct from the normative purposes underpinning other categories, such as rationality. Now, identification of archetypal propositions in turn imbues first-order propositions with further layers of meaning. We can now understand that the hearing rule is a manifestation of a deeper commitment to the normative goal of respecting dignity. Now, it follows that one can't hope to have a complete understanding of law absent consideration of archetypal principles. One will only have a surface level of understanding. Now, identification of these deeper commitments immanent in the law also carries further benefits. So when difficult questions arise over how the law should develop, second-order propositions provide navigation lights. They channel and discipline the process of norm manufacture. New norms are understood as being initiated into an ongoing enterprise directed to defined ends, and any legal changes will have to be capable of rationalization by reference to those ends. In turn, identification of second-order norms is critical to coherence. Absent a normative frame of reference, the law risks aimlessness. Now, interpretivism also imposes a discipline on would-be reformers by rendering explicit the normative value of legal propositions. So if one encounters offense, one must understand what purpose it serves before tearing it down. Otherwise, one won't know what will be lost or what negative consequences would follow. Now, a few quick fire points, which I can only touch on, but which are elaborated in detail in the paper. So there are certain ways in which interpretivism can go off track, including normative smuggling. So that's where the interpretation becomes captured by the interpreter's own ideological commitments. And the temptation of elegance, that's where the interpreter gets carried away with seeking to present a neat picture so that the account becomes distorted. And in the paper, I argue that the way to avoid these pitfalls is via a bottom-up approach, that is starting with the legal materials and working towards normative justifications, rather than top-down approaches, which start with a preconceived set of normative commitments. Now, the paper presents interpretive method as involving a creative tension between two parameters, fit and justification. Now, a couple of quick points on that. In terms of fit, one's interpretation must fit with an account of the normal, proper, and received body of legal practices. If the account is not plausible in the eyes of the interpretive community, then the interpretation will fail. So it follows that fit with legal phenomena is not a desirable quality of an interpretation, but a necessary threshold that an interpretation must meet. Now, justification refers to the normative justification the interpreter argues underpins and explains legal phenomena. And in the process of interpretation, the interpreter goes back and forth between their account of the legal phenomenon and the normative justification, refining each until an equilibrium is reached, whereby the justification explains the phenomenon. Now, importantly, final point on justification, the justification has to be one that offers a convincing justification for first-order propositions. That is, to be distinguished from a justification that one personally feels is desirable or ideal. So one has to put to the side one's own ideological predisposition and focus on what normative commitments are imminent in the historic system. Otherwise, interpretation becomes indistinguishable from normative theorizing. So that's interpretivism in a nutshell, and it's elaborated further in the paper. But let me leave you with the following concluding point. Whereas other fields, such as private law, have witnessed significant advances in doctrinally grounded theory, such work remains rare in public law, especially administrative law. It follows that we have an impoverished understanding of our field. The lack of interpretive work is also a significant missed opportunity for the academy. Developing a theoretical frame for understanding the law is one of the distinctive contributions legal scholars can make to legal knowledge that no other group in society can make. Such work is thus an opportunity for the academy to demonstrate its unique value to society. And as such, I'd encourage scholars to take up the mantle. Thank you.
Thanks, Jason. You make it sound beguilingly well structured. It's the advantage, perhaps, of being able to draw on private law as well as public law. Theunis, over to you. Thank you.
Thanks, Cheryl. I'd like to start by thanking Joe and Paul for their kind invitation to contribute to this book, but immediately also to apologize to them, because I feel that I probably didn't deliver exactly on the brief that they gave to me. So I was asked to write about comparative public law. And the chapter that I ended up delivering to them is more about presenting a certain conception of that field and how scholars should go about interacting in it. And that happened, of course, because that term comparative public law is somewhat ambiguous. It appears to refer to a method, but in fact, it's also the description of a field, comparative public law, that is organized around the fact that the participating scholars all do some form of comparison. But of course, there's no such thing as a single comparative method. And in any case, in my view, and I think you'd all agree, that methods follow on questions of epistemology and even ontology. So I did go meta, unlike the editors in their much more cautious approach. And my chapter is a kind of agonizing about contours of this field of comparative public law. It does get to methods, but somewhat sideways once I've done a lot of the agonizing. And I'll leave it to the audience to decide whether I completely misunderstood my brief or whether there was some rhyme or reason to my approach. So I started the chapter, naturally enough, by Googling comparative public law to see whether anybody else had tried to wrestle with this beast. And I found that notwithstanding the ubiquity of this term in the titles of research institutes, postgraduate degrees, even book series, Hart Publishing has a book series under that title, no one has thus far attempted to delineate the field of comparative public law. And of course, that's largely because the field is, or rather the difficulty of drawing the contours of the field is faced by two challenges. The first one has already been mentioned, and that's the difficulty of defining public law. As everybody here knows, there are different national traditions of public law, depending on whether you're English, French, or American. That term means something slightly different. And so naturally, in a transnational comparative field, all of those different conceptions of public law are brought into the field. And that makes the ontology of the thing, what it is that we're studying, uncertain right from the get-go. And then, of course, when you bring comparativism into the mix, comparative law as a field is itself still deeply contested between two main opposing views. The one of it is a view as a field is essentially legal research discipline, where social science methods can be brought in aid of the central enterprise of legal comparison. And a contending conception of the field, which is that comparative law is about all comparative research from whatever disciplinary perspective you might care to bring, provided that you're talking in some shape or form about law and legal institutions. So that contestation is present in the head field of comparative law, and it seeps also into comparative public law. So given all of those difficulties, what I decided to do was not to treat comparative public law as a field, but rather to approach it as a meeting place for three main traditions. And that's essentially what the paper is about, describing these three traditions and the types of comparative research that gets conducted within them, and then concluding with some remarks about how researchers who are working from within one or the other of these traditions ought to interact with each other in this field, in this broader meeting place. And the three traditions going in are what I call doctrinally oriented comparative public law. That term, doctrinally oriented, used very advisedly for reasons that I'll explain. And then qualitative social science, socio-legal research, qualitative social-legal research. And then a mainly American positivist social science tradition, mainly quantitative social science tradition. There are others, but to my mind, those are the three main research traditions flowing into comparative public law. So metaphorically, if we want to think about this, comparative public law is less a field, it's more like a vast lake into which these different research traditions flow, intermingling with each other, their currents passing over and under each other. So now, the next part of the presentation can get a little bit zoological. And so I don't want to take you through the march of the traditions. I'm necessarily, because of time, going to skate over the top of what's said in the paper. And I'm just going to try and give you a flavor of what's there in the hope that you might be interested enough to go and read it in detail. So to start with doctrinally oriented comparative law, and this is a nice segue, given that Jason has just spoken about doctrinal research. I ally myself with almost everything that Jason has said, except for that very opening remark, Jason, where you said that all legal research requires some knowledge of doctrinal methods. We can have a discussion about that. It depends, of course, on what you define as legal research, but there's certainly some legal research out there that treats law and legal institutions purely as the object of study. I think Donald Black being the most notorious of those exponents who believe that you could study law and legal institutions purely through the regularity of patterns of behavior observed in an entirely empirical fashion without understanding at all what the internal motivations of the actors was. Your retort, I think, would naturally be, well, it wasn't very good research or persuasive research, but we can have that conversation. But otherwise, I agree essentially with your depiction of doctrinal research. When you deploy the doctrinal method comparatively, of course, you immediately encounter certain obvious difficulties. If doctrinal research is insider participatory research, as you've described it, research that's aimed at reconstructing an ideal account of the philosophical basis for incoherence of legal norms in a particular system, how is it possible to do that authoritatively across multiple systems, to be an insider, both as a matter of socialization, of acquiring the necessary knowledge, and just as a matter of simultaneously being able to speak to insiders at the same time? That's the first challenge, I think. And then the second is when you consider the doctrinal method comparatively within public law, specifically of all the areas of law, public law is the one that is most often thought of as being relatively porous to other social systems, not hermetically sealed from politics, from matters of culture, for example. So you would think that doctrinally oriented public law would have a hard task of it. But in fact, there's a thriving community of scholars now who do engage in this style of research. And Jason is one of the scholars driving this. And I'm referring here to the biennial public law conferences hosted by the University of Melbourne and the University of Cambridge, which are constructing a doctrinally oriented field of public law. And they're able to do this, I think, notwithstanding these challenges that I've outlined, because they restrict the range of countries that are being compared to those that share a common legal heritage. And then the research is geared towards understanding the development and differential application of certain shared doctrines. So, as an example, substantive legitimate expectations arises in one common law system. Others react to that doctrinal development. And the researcher is really looking at each system almost as a laboratory experiment with a view to investigating and proposing doctrinal pathways not yet explored for their own system. So I think that's the way in which doctrinally oriented comparative public law proceeds. If one wanted to get even more zoological about it, I won't go into detail because of time, but one could say there's type one, which is pure doctrinal comparative law, where you adopt an insider participatory perspective in one legal system and you're treating foreign law simply as a source of law, as a persuasive legal norm in your own system. Then you get type 2A and B, where you're looking at a number of closely connected legal systems and you're comparing and contrasting the function played by a given norm in each jurisdiction. Sometimes you're wanting to contribute to the development of doctrine in all of those systems that you're considering, in which case it is properly doctrinal. But in other types of that research, you're looking precisely at the cultural factors that drive the different understandings of seemingly similar norms or practices across these systems. So most obvious example of that is all of the studies on proportionality conducted by Jaco Baumhoff, Ido Porat, and Vicky Jackson, for example, which are comparative in that type 2B sort. And then there's a third sort, which is the sort of harmonizing sort, which is looking at those differences with a view to drawing out similarities between them. So that's the first main tradition. I'm not going to go in as much detail as the others given time. But the second one is the qualitative strand in socio-legal studies. Again, we could have a meta discussion about what socio-legal studies is. My own particular song that I like to sing about that is that there are in fact two different types. There's social legal studies practiced by legal academics in particular, and then there's a broader understanding of social legal studies in the law and tradition, which is social science, external social science, studying law as the object of study, law and legal institutions as the object of study. I think the legal academic version of social legal studies is, of these three research traditions, the one that is properly interdisciplinary, in the sense that the legal academic brings their understanding of law in a particular legal system in the way that Jason's explained it, and then puts that law in context and tries to explain the development of law by reference to a range of criteria that's broader than purely immanent internal doctrinal criteria, and then also looks at the effect of law in society. So that's roughly what I'm talking about when I say the qualitative social science tradition. And deployed comparatively, you again get two types of that. You get single country case studies, which might appear to be a kind of a contradiction in terms. How can those be comparative? But in fact, there's a rich tradition of single country case studies, which are written with a view to comparison, written with a view to explaining the system to the outsider. Cheryl has written one of those on the Australian Constitution. And in fact, that entire Bloomsbury Hart series of constitutional systems of the world is exactly that kind of comparison. It's sensitive to the foreign reader and their desire to have the system put in context. And then you get small and multi-country studies, which produce or proceed along one of two main lines, either sort of typological approaches of the kind, for example, that Terry Halliday and his collaborators have done on the role of the legal complex in political liberalism, using a typological approach. Bruce Ackerman's work on revolutionary constitutions, for example, would be another instance of that. And then finally on this area studies, which do something similar to what's being done in doctrinally oriented public law research by reducing the compared countries to those that share presumptively a certain common heritage that makes them comparable. And then the final tradition is the mainly American tradition of quantitative positivist political science research on public law. There's a separate chapter in the volume on this style of research as it exists within the US. So it's that style of research that has grown out of what was originally called in the United States the field of public law, which meant something completely different from our understanding of it. It was the science of government, a field of political science, as it started in the early 20th century US, and then was hit by 3 epistemological waves over the course of the 20th century, by behavioralism, rational choice, and historical institutionalism, all of which then produced their own particular styles of study, mainly of judicial decision-making. And all of those styles of study of judicial decision-making in the US now have their comparative equivalents, which I go into in the chapter. And then finally, on that research tradition, there's the emerging field of empirical constitutional studies, which is the work of Mila Versteeg, Adam Chilton, David Law, and scholars like that, who are taking the texts of constitutions, large databases of the texts of constitutions, and running various quantitative regression analyses on those databases to ask questions about why it is that constitutions endure, what makes them endure, and whether constitutional rights make a difference, for example. So it's a very, very complex, broad, multifarious field if you take all of those research traditions into account, each of which is complex in its own right. So given all that heterogeneity, what are we to do in this field? The leading work in this area is obviously Ron Herschel's comparative matters, and he sets out an idea of a slightly narrower field of comparative constitutional law as comparative constitutional studies, calling for a big tent multidisciplinary conception of the field. And I think most people have signed up to that conception, and it's been very influential. But as Joe said at the beginning, the conversation that we haven't yet had is about how to do interdisciplinarity within this field. And another thing I did for purposes of this paper was to have a quick sort of word search of the situations in which the term interdisciplinary is used in the International Journal of Constitutional Law and other key texts in the field. And 99% of the time that term is used, it's used really to mean multidisciplinary rather than interdisciplinary. So it's used in reference to an anthology of papers, the contributors of which come from different research traditions. So I think the next phase and the next challenge for the field is to think through this question of how these scholars from these different research traditions flowing into this field, interacting with each other in this single meeting place, actually relate to each other. And the final part of the chapter suggests 2, again, archetypes of interaction. One of them is benign toleration. That's just where everybody accepts that somebody's coming from a different tradition, doesn't engage with the paper, trusts the internal review process in the disciplinary journal concerned to weed out any problems with the paper. And a second ideal typical conception of this form of engagement, which would be critical engagement, where scholars from the different traditions do pay attention to each other's research and challenge it from within their separate paradigm. And examples of this are already emerging with the empirical constitutional scholars, for example, explicitly challenging many of the empirical assumptions going into qualitative research, and equally qualitative researchers challenging some of the conceptualizations that are deployed in quantitative research. So I'm hopeful that the field is maturing in that sense, and that we're beginning to interact with each other in that more constructive way. Thank you.
Well, thank you, Theunis. You might have departed from your writing instructions, but your meta approach, I'm sure, is going to be attracting a considerable amount of interest. Diane, can you put the pre-recording of Janna's presentation on, please?
Hello, I'm Janna Promislow, and I am joining you by recording from the University of Victoria in British Columbia, Canada, also known as Lekwungen and Wasanich territories. I'm delighted to join you. I'm sorry it is through a recording instead of as a live participant in this seminar, but I appreciate the center accommodating me with this format given our time zone difficulties. If you do have questions for me, please feel free to reach out to me by email, which I've listed on the title slide here. So my talk today is about research questions and issues that come up in relation to Indigenous contexts. I'm quite focused on the Canadian context and aware that some of the structures and institutions are different across our different jurisdictions, but also that an awful lot transfers and is interesting in terms of comparative perspectives. I'm going to talk about some key premises and approaches in my work, and in the chapter that this seminar, from the volume that this seminar is based on. I'm also going to talk about self-government context in Canada, and this question of the relationship between state law and bodies recognized within state contexts and Indigenous law founded bodies based on an inherent governance authority. And then I'm going to talk a bit about the implications of those different contexts for public law research and Indigenous law research specifically, and I'll end my talk with that. Some key premises and approaches for this work of public law and specifically administrative law in relation to Indigenous contexts and in relation to Indigenous law and Indigenous law research specifically is an idea that law is itself evolutionary. It's not static. And this is important in the context of Indigenous issues and working with Indigenous peoples because there's been quite a bit of static approaches to the concept of indigeneity, to what it means to be Indigenous, and to the types of lives and aspirations of Indigenous peoples. And so all law evolves, and that includes Indigenous law. Another key premise is that internal perspectives on law are critical to identifying and working with law. This is true in any legal traditions. The doctrinal work of law is done of common law is done from an internal perspective. And as I reach the end of this presentation, I'll be talking about the importance of internal perspectives on the work of Indigenous law research. And so hopefully not too controversial a premise. A third premise or approach is that Indigenous peoples are peoples who have law, and that law is equally legal in character. For example, as compared to law in common law legal systems. Nobody questions that there's law in a common law legal order or a state with a common law tradition. But when we're talking about Indigenous peoples, the importance of this has been emphasized by many of my colleagues at the University of Victoria, Indigenous scholars such as Val Napoleon and John Burroughs, is to understand Indigenous law as equally legal in its character. And the importance of that comes from the long colonial history in which the local law of Indigenous peoples in what's now British North America were treated as lesser in status, whether it's through a principle of terra nullius or through the concept of custom as something lesser. And so this research, this current iteration of this work starts from an approach that recognizes the equal character of its legality. Nevertheless, it remains difficult to work across in comparative, or as we call here, trans-systemic approaches to common legal problems, to the common problems that people have in organizing their affairs through law. And it's difficult to work across common law and Indigenous legal orders in Canada, for example, because we do not find similar ways of articulating law. We do not always find, we generally do not find similar institutions interpreting or creating law. Now, we do also have lots of institutions that create law that are familiar to state institutions in Indigenous contexts, and that's a part of what I'll talk about, the way that those contexts overlap. Right. And a final premise or point I make in the chapter is that Indigenous law research is part of a process of revitalizing Indigenous legal orders and is supportive of self-determination. And this is an important approach because it understands that the research questions around Indigenous law are formed by Indigenous nations and communities, and not coming from an outside researcher who has a lot of curiosity, such as myself. And so the role of the researcher is affected by this, the ethics of research are affected by this, and it characterizes the whole process of research. And it also understands that Indigenous law is part of an expression of self-determination, that an Indigenous nation seeking to be more self-determining will get a lot out of a process of articulating and reconsidering legal norms that may be implicit in other processes within the community, and share the understanding within the community. And so in that sense, Indigenous law research is supportive of self-determination. Okay. So to talk about that in less abstract means, we'll talk about self-government and context in Canada. Self-government in Canada, I've at the risk of great oversimplification, I've created two boxes, and I've drawn a distinction between the sources of authority of the governments in question, of the decision makers in question. We have in Canada well-known Indigenous governments known as First Nations bands and band councils. And those are recognized under legislation, longstanding legislation, much criticized legislation known as the Indian Act. And the Indian Act doesn't create these governments. It's a historical process that's now reflected in the Indian Act. And we see that, excuse me, in Section 2 definitions in the Indian Act, where the legislation doesn't create the band, but it recognizes that there are bands. There are those whose reserve lands or monies were set aside and held by the Crown before 1951, which was a key revision of the Indian Act, or those that are declared by federal cabinet to be a ban for the purposes of the Act. So it sort of takes the recognition piece as really a more political process. There's a declaration that recognizes the existence of a First Nation ban. The bylaw making authorities of the band council, the government of the band, look a little bit more like a delegation of bylaw making authority, more similar to something like a municipality. And so in our jurisprudence, in our public law jurisprudence, First Nation bands and band councils are, for the most part, understood to be like other state decision-making bodies, part of the common law processes of judicial review. I'll come back to that point in a moment. In the other box, I've specified the idea of governments that are founded on inherent authority and or Indigenous law. So an authority that Indigenous peoples had before the creation of Canada in 1867, before the creation of the colonies that became Canada. And we see reference to these governance bodies as traditional or hereditary. And a couple of examples I've noted and linked are the Wet'suwet'en hereditary chiefs. The Wet'suwet'en hereditary chiefs are a government for the Wet'suwet'en nation that sits alongside and is separate from existing Indian Act band councils, also confusingly called Wet'suwet'en. some of them. And so though the Wet'suwet'en have taken court case, the hereditary chiefs has taken court cases forward with their Gitxsan neighbors. The Delgamuukw litigation was brought by the Gitxsan as well as the Wet'suwet'en hereditary chiefs. And so we see them as legal actors in Canada, but there are some differences to take note of when we're dealing with governance bodies who do not source their authority in state law, in legislation, or really have clear recognition even in, we don't have clear recognition of that inherent authority in the Constitution either. The Section 35 right to self-government is poorly developed in the jurisprudence, and it's not explicit in the text, right? So it remains sort of questions of constitutional law. And Council of the Haida Nation is another example of a body created by Indigenous nations without reliance on state instruments, and yet has a role as a legal actor in Canadian public law. And a role as an actor in Canadian public law anticipates this next point on the slide, that the contexts overlap. There's no clear divide between exercises of Indigenous law and or inherent governance authority and exercises of authority under legislation such as the Indian Act. So we have examples of this overlap that I've linked in the context of what are understood to be delegated bodies, such as First Nations band councils. We have a long jurisprudence of judicial review, and we have recent jurisprudence from the federal court in Canada considering how Indigenous law appears in the First Nation band council context. Specifically within the Indian Act, there's a provision for customary basis for elections, and this gets reviewed by the federal court in a number of different contexts, and also in relation to incorporating Indigenous law in bylaws. There's a quite a recent case from the federal court, Bastian and Jackson, dealing with the incorporation of Piikani Nation, a nation from the southern Alberta region that has names Indigenous law principles within its bylaws. And so how is the court dealing with these expressions of Indigenous law that are not fully derivative, or the relationship to the legislation is different? And then in the context of inherent authorities, inherent authority bodies, there's a lot of different ways in which they interact with the state. And so we have more recently in federal legislation recognition of Indigenous governing bodies as a definitional unit that may be delegated authority in, for example, federal development assessment processes, or in family services, child welfare and family services legislation and the provision of services within a community. There's recognition that the body doing the work is not necessarily one that is articulated in legislation and delegated the authorities. Okay, so there's this sort of overlaps that are really interesting. With the previous slide, I'd mentioned that both the Wet'suwet'en and the Haida, and there are many other examples, are bodies that have acted and been recognized as parties in courts without concern with the source of their authority. Nevertheless, the source of authority for an actor is, I'm sure many of you recognize, an important question in public law and in administrative law, and important for understanding the role of the court in judicial review, whether it takes jurisdiction, whether it considers the issues justiciable, all of these matters it's relevant to. With the delegated bodies, self-government bodies, we have a long jurisprudence recognizing that they are amenable to judicial review. Whereas with the inherent authority bodies exercising Indigenous law, we don't really have that clear jurisprudence. There are a sort of a sidebar, which is quite interesting for thinking about public and private contexts in relation to the concept of public law. There are a number of traditional governments who, for different purposes, such as receiving funding from the state, will take on nonprofit corporate forms, societies. They'll incorporate as societies or nonprofit corporations. And we do see that through the Societies Act that there's some review of their actions that sits, again, not in the public law context, and is because of specific choices to incorporate or needs to incorporate to participate in some negotiation context, such as the treaty process in British Columbia. And so that also sets up interesting problems and questions. But with respect to public law judicial review in Canada, we have not, I would say, not a really well-developed jurisprudence with respect to issues and decisions coming out of inherent governance authority contexts. And given those different positions, we end up with, relative to the state, we end up with some different approaches and different questions for research. The delegated bodies raise a lot of questions about the role of judicial review and the concepts of deference that a judge may apply, or their approach to deference in reviewing the decisions of self-governing and often elected bodies, again, who may in some instances or some aspects of their decisions be reaching into Indigenous law and law that is not common law and not derivative of the state legal order. And again, they're all on top of each other. It's not to separate them out, but that's part of the context of judicial review and part of the doctrinal questions that can arise there. And then with respect to inherent authority bodies, well, you know, as I said, the sort of judicial review of those bodies is not well developed. And the questions about that arise are really going to be centered and described within an Indigenous law context and world. Okay, so the Indigenous law questions that arise that relate to public law are really about ideas of what kinds of values and norms within that Indigenous legal order are guiding decision makers, or what processes are there for accountability, and how do the citizens participate in the decision making of the government. So those are the kinds of things I would describe as public law questions relating to an Indigenous law of a nation. And you have to just sort of take out the whole frame of judicial review there and ask those questions on the terms of the Indigenous legal order itself. And having said that, I think it's important to be able to frame research questions with respect to Indigenous law from within the Indigenous legal order. And if you do that from within the Indigenous legal order, I have a lot of questions about, I wouldn't want to assume really that the category of public law has great meaning or importance. For me, the category of public law as a category of research within Indigenous legal orders is one that has to be asked as a question itself. Is this important? Is this useful? And when we're asking, is it helpful or useful? It's a question that relates to, is it important to the Indigenous nation? So Indigenous law research, again, going back to the premises and approaches, is research that serves a community, that serves aims of self-determination. And it's not necessarily important to separate out public law from other types of law and principles for decision-making. It's something that certainly is of interest to me as a researcher in the area, as someone trying to teach in a trans-systemic legal program around Indigenous, around administrative law. So many of these things would be very interesting to me, but I think it's not necessarily interesting to a community to try to articulate. It's not necessarily helpful or related to their research aims to try and articulate whether there are distinctive public law principles. So I flag that as an important question and prefer to just talk about Indigenous law research. And then relating to this issue, as an example, I've linked a report from the Indigenous Law Research Unit, which is an institute at the University of Victoria that works with communities. And the report and the pages I've flagged are examples of how they work with the community to define the questions. And also, for me, I look at things like their discussions of the institutions of lawmaking that allow some kind of comparative work with the common law, or help me understand decision-making processes within an Indigenous law framework. The particular report I've linked is related to child and family services work. And you can see that any questions that might be interesting to people doing public law research are, not framed specifically as that. Lastly, I'll just finish off with a quick word about challenges and opportunities. As I was just speaking, Indigenous law research serves Indigenous communities' needs. That's often a misfit with academic priorities. I have a lot of questions that I'd like to ask that I just understand are not necessarily top of the agenda for a community. So that's not a great place to start a relationship or a project. It's really got to be formed around what's important for communities in their work with academic researchers. Accessibility can be challenging when we're working with Indigenous law internally within communities, but also with outsiders. The outsiders part is probably obvious, but within communities, we have to understand that revitalization process, that rebuilding process that is part of Indigenous law research is there in part because of colonial processes that have fragmented communities. And so in Canada, for example, we have reserve lands and we have members of First Nations bands, and often only about half of them live on reserve lands, with other people living elsewhere and being educated elsewhere, given economic and social and services, government services types of conditions. And so, the conversation around Indigenous law is often has an aim of working with the community to rebuild knowledge and to sort of share between knowledge holders and knowledge keepers and those who haven't been educated within their own systems. Indigenous law can also be quite specific about time and place in the sort of exercise or the operation of that, of particular law and particular processes. And really for outside researchers to have access, they have to actually participate in those Indigenous legal orders. But the last point is a point of opportunity. Indigenous, these questions I have about whether there's a distinctive Indigenous public law should not take away from the idea that Indigenous nations have very rich traditions of stuff that we would associate with public law. In the Northwest Coast cultures, Pacific Northwest, where I'm located, there are many traditions that demonstrate this sort of richness of consultation and participatory government and decision-making within nations, within communities. Certainly my colleagues such as Val Napoleon have done a lot of work that allows us to really dig into the processes of the feast house. Anthropologists, there's a whole record out of the Delgamuukh litigation that does give us some access to think about and talk about, although not decide for the community, the nature of the law that's operating around public bodies and decision-making. So hopefully that wasn't too contradictory at the end, but I'll leave those thoughts with you, and thanks very much for listening.
Let's move to the first of the questions in the Q&A box. So the question is this, everyone. Thanks for the great insights all. I have a question for Jason. Have you got any specific examples of topics within admin law that you identify as particularly ripe for new research that's more methodologically rigorous? Or was your observation more that administrative law is generally less strong in methodological rigor compared to private law? Jason.
If I focus on Australia specifically, I think because the High Court has pinned particular or the doctrines of review to statutory interpretation, holding that procedural fairness or rationality and so on are implied statutory restrictions on the exercise of power. This has perhaps discouraged the court, and this has had a flow-on effect on scholars, from interrogating the normative underpinnings of these principles, because they're just seen as flowing from Parliament's intention. But of course, there must be reasons why we have procedural fairness. There must be reasons why we have rationality, why these constraints in particular. And it's important to interrogate the normative underpinnings of these particular principles of administrative law for the reasons that I elaborated in my talk, which is that when we decide how particular doctrines, like the hearing rule, bias rule, or say materiality, for example, ought to develop, or whether new doctrines ought to be recognized, we need to have an understanding of the normative enterprise within which we're engaged to ensure that the law develops coherently. So, whether a particular doctrine, such as say materiality, is normatively justifiable within the internal perspective of the law, may depend on whether procedural fairness is underpinned by a principle of dignity, or whether it's underpinned by a concern to promote good, accurate decisions. For example, now, if you look at a case like MZAPC, the majority simply refused to explore the rationale for that the doctrine of materiality or the substantive norms to which it pertained, whereas the minority judgments started from what they consider to be the normative underpinnings of the field of judicial review and worked outwards from that. And that's a much richer sort of doctrinal approach. It's just that the normative dimensions of the majority's view are hidden from view. So I think in Australia, given that there's been this preoccupation with statute, what's been missing, I think, from judgments, and also it's had a knock-on effect on scholarship, is a direct interrogation of the normative underpinnings of many of the doctrines of judicial review. And the law and scholarship is impoverished to the extent that work has not been done. But on the positive side, there's a real opportunity. And I think there are the beginnings of normative inquiry within the Administrative Law Academy.
Thanks, Jason. I had a small bet with myself that materiality might make it showing.
How could it be avoided?
I don't know. We have another question from Ros Dixon, which I'm going to put because I think any one of our speakers can answer it, but Theunis, you might have the first go. Thanks all. How do we encourage the respectful exchange Theunis mentions, or the doctrinal theorization that Jason points to in how we teach undergraduate, JD and doctoral students? So Theunis, do you want to have a go at that? And maybe Joe, if you've got views, you can also come in on it.
Thanks, Cheryl. Well, it sort of has an easy answer and a hard answer. The easy answer is we're already using Jason's chapter. Some 5 months ago, I think you'll recall, Jason, I asked you whether we could prescribe your chapter for our higher degree, for our honours thesis students. So at UNSW, we're actually already exposing them to that. Our honours program is deficient in many ways, and I wouldn't be claiming to say that we're doing anything like state of the art. As many of you know, UNSW adopted a trimester system 3 years ago, and so the entire honours program is railroaded into a 10-week term. So the poor honours students are expected to produce a 10,000 word thesis in those 10 weeks. And all we really do for them in the honours workshop that we run at the beginning is a kind of a one-day overview of legal research that at least enables them to situate their research within the broad field. But we don't actually offer anything like detailed research methods training to the honours students. We're revamping our PhD training program as well, which hasn't been very much more elevated, in fact, than what I've just described as being offered to the honours students. And we're going to roll out a kind of a 3-year program. Sorry that I'm just talking about my own institution, but that's all that I know about. And we're going to roll out a 3-year program that starts, with all the big questions of epistemology and method, and then works its way towards the particularities. So I think certainly at the UNSW, I'll conclude with this, we are trying to go back to an older understanding of what a PhD is about, to that understanding that it's sort of training in a discipline, training in a field, that you're not just capacitating the student to know narrowly just enough to write an examinable PhD thesis, but you try to equip them to be a cooperative, interactive, collegiate scholar in the broader discipline for which purposes they need to have a broader understanding of methodology. So it's a slow process, as I think everybody here will appreciate, but we are committed to it. Thank you.
Thanks, Theunis. Joe, do you want to say anything about Ros's question?
Sure, yeah. Just to echo very much from the UK perspective, what Theunis already said is that within a traditional law degree, we teach at undergraduate level law here. So we don't really have space to teach methods, and I don't think many law schools even have a session on doctrinal methods. We tend to have legal skills sessions and things like that. But again, a lot of the kind of background methodology is assumed and implied. And in many ways, I think we do a disservice to our students by not being clearer about that more, because it's essentially left for them to figure out. One of the things that I have seen work quite well, though, in the UK is the Economic and Social Research Council, which funds an awful lot of PhD students in the UK, has a 1+3 model where you have to they'll fund a master's degree followed by a PhD. And the one is typically a social research methods course. So that will expose a student over the course of a year before a PhD to quantitative research, to qualitative research, and other kind of research in the context of their proposed project. My experience of supervising students who've gone through that process is that you get a different kind of PhD student. Is you get one that's much more capable of reading different kinds of literature, one that's more has a deeper understanding of different kinds of methods. And so I'm quite supportive of that kind of approach. That's obviously at a more advanced PhD level, but it's difficult to imagine ways that we can kind of cram this kind of methodological complexity into an undergraduate law degree where we have to teach them so much law.
Yeah, thanks. And Jason, do you want to come in on this too?
Yeah, so I'll address the second part of Ros's question, which how does one bring doctrinal theory into sort of undergrad courses, right? And I think it's echoing the points that have been made. These courses are increasingly cramped with material. I mean, in terms of sort of teaching students doctrinal methods specifically and encouraging them to engage with the normative dimensions of law, to interrogate the normative underpinnings of particular propositions. I suppose in parts that might, one way of thinking about how that might be integrated is a reorientation of courses, so that instead of focusing on getting through a whole lot of material, which students generally forget after they leave the law school, one should focus on training them in legal reason and legal thinking, which is ultimately what will stay with them once they've left law school. And of course, there are these various criteria imposed by administrative bodies requiring that we have to teach so much of this, a particular principle, particular of law, and so on. But maybe in advanced or elective courses, for example, one could focus more on legal reasoning. But I also think even in undergraduate courses, when one's introducing a particular topic or subject matter, one can set out different theoretical lenses through which the topic might be viewed to introduce the idea of normative contestability, the idea that the normative foundations of law are contested, and what view one settles on in terms of normative foundation shapes what the law ought to be. But I'll just mention lastly that at Melbourne, we teach a final year course called Remedies, and that's a private law course, but some of the lessons might be translatable to public law. And in that course, we consider remedial principles in contract, tort, and equity, so different fields of law. And that encourages students to become nimble at moving across legal categories, but also encourages them to think about what makes contract different, what makes tort different, what makes equity different, and how does that shape legal doctrine, and specifically in that course, how does it shape legal remedies? So, I mean, we refer to that as a capstone subject in the managerial language of the modern university. But it's quite a nice way once students have learned the relevant material to then get them thinking as a lawyer.
Okay, thank you. Last question on the list, but I've skipped over one to which I'll go back if we get a chance, but has some overlap with what Janna might have said, and maybe something that also several of our panelists want to address. The actual question, though, is directed to you, Jason. If a law or legal rule must be rational, what's the role of culture in interpreting law when culture appears irrational?
It's a big question. One of the questions of our age, I think. But I mean, so one observes in obviously is often remarked on in broader culture. Political polarization has become a defining feature of our time, and it's intensifying, and the reasons for that are complex, but nonetheless it's with us. I mean, I think in politically fraught times there can be perhaps a greater temptation for scholars to bring in political commitments into their accounts of law, and we've seen a recent debate about activism in law. I mean, in terms of doctrinal scholarship, I think what disciplines it is that whatever your account of the law is, it has to be one that will be recognized as plausible by the interpretive community. So if one starts to bring one's own ideological commitments in, that will likely distort one's account in such a way that it will no longer be seen to be plausible as a plausible account of the law in the eyes of the interpretive community. I mean, lawyers have a sense where someone is trying to sell you something, but one can see how, you know, an intensification of political polarization could filter into and distort legal reasoning. And we need to be attentive to that division between seeking to give an interpretation of something, the law, and normative reasoning. So I think one should be disciplined, and in the sense that one needs to identify the normative commitments that are imminent in the historical system, rather than imposing one's own normative commitments. And then if that shows the system to be unjust, then one can say, right, that one considers it to be unjust and how you believe it ought to be reformed. But what can be dangerous is to seek to, if one thinks the law is unjust, to seek to impose one's own normative commitments to provide an account which shows it to be just, but that can end up hiding injustice, so that that we don't recognize the law is unjust, so that it can then be remedied. So it's a difficult question. It's a large question, but I hope I've offered some insights. But I wonder whether Joe and Theunis might also have some views on this.
Yeah, no, I think very much so. Theunis, do you want to start, and Joe, then you maybe come in if you want to.
Well, I mean, I'd have to start by questioning the opening premise, which is whether culture is irrational. And then separating the question out into whether you're talking about the role of culture in legal reasoning versus the role of culture in my field in comparative method. And those are two very different things. So I think a lot of what Jason was actually talking about was, in fact, the rationality of legal professional culture, right, Jason, and the stabilizing role of legal professional culture. So if one had to sort of hazard very riskily a kind of a definition of culture, it's all those sort of assumptions and expectations and values that a community carries into a situation without necessarily being consciously aware of them or having to explicitly articulate them. So utilizing that understanding of culture in legal interpretation, it's very much Carl Llewellyn's notion of the stabilizing role of legal culture, what makes decision-making reckonable. It's not that rules of interpretation and rules themselves have a semantically determinate meaning. It's that the community of interpreters brings this culturally attuned, stabilized set of expectations to the interpretive act. And that means that broadly across the field of interpreters, there's likely to be more agreement than you'd otherwise expect. So that's the kind of rationality of culture. But in comparative law, of course, the role of culture is one of the grand themes, most famously in the dispute between Alan Watson and Pierre Legrand, where Pierre Legrand adopted a whole wholly culturalist view of law, and critiquing the idea of any sort of legal transplant being possible, because as soon as the legal norm lands in the receiving legal system, it's exposed to the cultural thought ways that give it meaning which might substantially change the meaning that it had in the originator system. So there's just that spectrum of views in comparative law, from the view that the cultural dimensions of your law, extreme view, make any kind of comparison virtually impossible, to the more optimistic view that there are certain universal ideas, concepts that, if pitched at a sufficiently high level of abstraction, can somehow escape their cultural moorings and attain a sort of a transnational status, and then travel and then be particularized in the local setting. But that view obviously also is very controversial, particularly when the ideas that purport to have universal validity just so happen to be mostly Western ideas, Western liberal ideas, that criticisms from the global South are exposing for all their cultural particularity, their provincialness. So that's as much as I can say about it.
Thanks, Theunis. It's worth a seminar in its own right, this question. Joe, last word for you, if you wish to take it.
I don't have too much more to add on the question of culture in particular, but just a thought that has come up again and again during the construction of the book is who are the interpreters of law? So whose culture are we looking at? And often we tend to focus on judges, courts, but in pretty much every system of public law, the primary interpreters of text are going to be public officials. And then you have obviously other parts of the state also have a role. You have in many ways legislatures interpreting law and legal text in lots of interesting ways, in ways that we don't necessarily have a deep understanding of. And then, of course, there's the public as well, in how they sort of interpret these kind of rules. So I just thought I'd add that to the discussion, as I think it's a really important frontier of legal research. And there was a terrific book written by Richard Martin on how police officers interpret human rights laws. I think there's some really interesting observations about culture in that.
Mm. Thanks, Joe. Look, we're going to have to bring this very interesting seminar to an end. I regret that because we have two wonderful questions still remaining, one from Daniel Goldsworthy and another from Anne Carter, but I draw our speakers' attention to them, and maybe they could think about them and maybe even get back to the questioners if that seems appropriate. But can I just close by thanking a few people, thanking Diane and Lindsay Bladen in particular for all their support for this seminar, which has been fantastic. And finally, let me thank our three speakers for today, Theunis, Jason and Joe. Really fantastic presentations. The questions were wonderful from the audience, and it's clear that Joe, you and Paul have started a hair running, which will attract a lot of people in pursuit of it. So thank you all very much and have a good evening.